Hello, my name's Ian Larkins of Radius Law and welcome to our monthly commercial bulletin brought to you in association with LexisNexis. The new International Financial Reporting Standard, IFRS 16, has been published and will be applicable from the 1st of January 2019. IFRS 16 requires all lessee leases to be recorded on the balance sheet as both assets for the right to use that leased item and as a liability for the present value of its lease payment. To put a correct value as a liability, companies will need to have detailed insight into their lease agreements. A recent case involving the lease of an aircraft engine has given a warning to business customers that signs sold as seen terms. In this case, the terms stated that by signing the acceptance certificate, the lessee confirms it has had the opportunity to fully inspect the engine to its full satisfaction and to satisfy itself that the engine is in accordance with the delivery conditions. The engine subsequently suffered a major failure and the lessee sued. The court struck out the claim. The lessee had signed the terms and the fact that he had not actually inspected the engine was irrelevant. With many contractual claims and particularly restrictive covenant claims, it can be hard to prove a loss. To deal with this, courts in some cases have allowed release fee claims. The idea being that if a person breaches a restrictive covenant, he or she should at least be obliged to pay the hypothetical sum that would have been agreed to buy the person out of the restriction. There has, however, been some uncertainty about whether a release fee claim can be sustained. The Supreme Court has now shed some clarity on the issue in the recent case of Morris Garner v. One Step by stating that release fee claims are available but only in exceptional cases. It seems that the dividing line is whether it is possible to quantify the losses or not. Unfortunately, the Supreme Court failed to provide a helpful checklist of when a release fee claim could be sustained. So it is likely that there will be further cases to test this area of law. The European Commission has published the text for the replacement of the e-Privacy Directive. The directive, which deals with electronic marketing, is expected to be enforced in 2019. The good news is that terms have changed from the earlier leaked drafts, particularly that business-to-business e-marketing will not need prior opt-in consent. There are still opportunities for amendments, but for now we can breathe a sigh of relief. For consumers, e-marketing stays as it is today, namely consent is needed, but there is the soft opt-in rule that, subject to some restrictions, allows e-marketing to existing customers for unsolicited marketing of similar goods and services. For telemarketing, phone calls to consumers that currently can continue with an opt-out basis look set to change to the similar rule that we have for e-marketing, unless the UK chooses to take a different route. The much-awaited decision in the Employment Appeal Tribunal case of Ali v Capita has now been released. This case concerned Mr Ali, who asked for enhanced 14 weeks paternity pay that his female colleagues were entitled to for maternity leave. Although he won at the tribunal, the decision was overturned by the EAT. The EAT's reasoning was that maternity pay is inextricably linked to the reason for maternity leave, which is the health and well-being of a woman in pregnancy, which is not comparable with a man on shared parental leave. The Court of Appeal has confirmed that employers that expect long working hours may need to make reasonable adjustments to those expectations for disabled employees. The Employment Appeal Tribunal has determined that agency workers should be granted the same leave and rest break entitlements as permanent employees, even where the permanent employees have a lower hourly rate of pay. The EAT has, however, acknowledged that it may be possible for agency workers to receive entitlements to rest breaks and annual leave by a different payment mechanism, but this would need to be transparent. The EU has announced its planned package of reforms to deliver a new deal for consumers. These include GDPR-level fines for breaches that cause mass harm, consumer bodies to be able to bring actions to seek redress on behalf of consumers, but claimant law firms will be barred from bringing such claims. New rights for consumers to seek compensation when they have been affected by unfair commercial practices, such as aggressive or misleading marketing. New rules to limit the practice of so-called dual quality products, whereby manufacturers provide inferior quality products to some markets. More transparency for sales on online marketplaces. There is also expected to be some consumer rights limited or deleted. Consumers will no longer be allowed to return products that they have already used more than permitted, and traders will not have to reimburse consumers before receiving return goods. We expect the proposals to be law by May 2019, but there will be a 2-year transition period. New guidance on delivery charges for goods ordered online has been issued by CAP. Its enforcement agency, the ASA, has been granted the ability to carry out targeted enforcement for non-compliance. The guidance makes it clear that charges should be clear and not misleading. If a delivery charge applies per product and the charge cannot be avoided, then it should be included in the price. Claims such as free delivery should be genuinely free and not subject to minimum spend or admin charges. Also, charges should be made clear, upfront, and not only when it gets to the checkout stage. Detailed guidance is available on the ASA's website. Joint ventures and collaborations can create synergies and bring benefits to consumers, but they can also be harmful to competition. It is easy to breach strict competition laws, particularly when exchanging information before the deal has been agreed. Breaching the rules can expose companies to blockbuster fines. The Competition and Markets Authority has now published new guidance on how to manage a joint venture, which is available on its website. In February, we reported on the Coty case, where the European courts had ruled that luxury brands can stop their authorised distributors using third-party online platforms such as Amazon, provided such a prohibition is appropriate and does not go beyond what is necessary to preserve the luxury image of the goods. The Düsseldorf Higher Regional Court has now reached a similar view for physical shops by allowing a luxury goods manufacturer to prohibit the sales of its products by a food retailer. Thank you for tuning in for this month's commercial bulletin. For more information on any of these stories, please contact Radius Law or my colleagues at LexisNexis. We'll be back in May with more of the month's key legal updates.